Good evening, everyone. I'd like to start today's discussion on equity, specific relief, and the impact of the 2018 amendments by sort of giving a brief on what will be undertaken and discussed by me over the next 30 minutes or so. I'd like to start by saying that I do not intend, and this webinar is not a primer on specific relief in India. It is not also a primer on equity. The subject is too vast to be discussed over a 30-minute webinar. I've also noticed far too often that in litigation practice, we lawyers don't tend to look at the Specific Relief Act and its remedies in the context of understanding the legal principle or the basis behind it. So what I intend to do today is to discuss and spend 30 minutes to understand the equitable origins of specific relief, particularly specific performance, and thereafter talk about the 2018 amendments. I'd like to actually start by what I believe is going to be my central argument to set it out beforehand. At the core of this talk, the central argument is that the 2018 amendments have, without any discussion and with a single stroke, changed the entire basis of specific performance in India. Primary amongst those bases is the requirement that specific performance will only be granted by a court where damages are an inadequate remedy. This basis has been done away with the introduction of the 2018 amendments to the Specific Relief Act, and without any understanding whatsoever, there are no notes and clauses. There's only a one-page statement of objects and reasons. So there is hardly any direction for us lawyers to understand why this was done and on what basis this was done. My argument is that perhaps the answer could be in the 1859 Code of Civil Procedure, section 192, which I'll come to later on. The basis of this webinar is the outcome of research undertaken primarily while I was an assistant professor at Jindal Law School, teaching commercial remedies, and currently while I'm editing a book on specific relief in India. So without much ado, I'd like to start with the historical origins of specific relief. I wasn't taught this in law school. In fact, Specific Relief Act was taught over just 2 days in an entire semester for me. I only took up the interest after my further studies in the UK, wherein I felt that this was a very engaging area of law. So to start with, we need to understand the origins of common law and equity. In 1066, after the Norman conquest of England, for the first time you had the entire territory of England being regulated by a single law. And this law was actually the law as administered by the king. It took its origin as common law because this was law that was common to the entire territory of England. However, the king could only pronounce the law in certain aspects. Where he could not pronounce the law or where an issue was not regulated by law, the aggrieved party could petition the king and say that this is not covered by it, and the king would thereafter, in equity and good conscience, decide the matter. This second aspect, that is the unregulated area of law, gave birth to equity. Now, as things stood at that point of time, equity was administered by the king, but more and more it was realized that the king could not on a regular basis just administer equity. So he sort of outsourced this decision making or adjudication to the Lord Chancellor. The Lord Chancellor was considered the keeper of the king's conscience. For readers out here who have read Hilary Mantel and Wolf Hall, Thomas More and Cardinal Wolsey were actually Lord Chancellors in whose time in the 13th and 14th century equity really gained prominence. As things stood, administratively, common law was regulated by a procedure that was before the King's Bench division. Currently, you have a queen in England, so it's called the Queen's Bench division. Simultaneously and side by side, equity was regulated by a chancery division. So you had common law courts being King's Bench courts, and you had equity courts being chancery division courts. That distinction is maintained till date. But it had a problem. And the problem prior to 1874 was that if you went to a common law court, you could only get a common law remedy and you could not ask for an equitable remedy. If you went to an equity court, vice versa, you could only ask for an equitable remedy and not a common law remedy. Just give me 1 minute, please. In literature again, the problems with the equitable court and chancery division are best sort of held out or set out in Charles Dickens' novels. Charles Dickens was a clerk to a judge in the chancery division, and most of his novels, specifically Bleak House, talking about Jarndyce versus Jarndyce, the fictional case that is, sort of highlighted the problems of delay and the manner in which equity courts are administering jurisprudence. So because I now come to a next aspect. Now I set out earlier that you had common law courts giving common law remedies and equitable courts giving equity courts or chancery courts giving equitable remedies. But what are these remedies and what are the various aspects of law that were regulated by these two courts? So common law courts primarily looked at contracts, torts, some aspects of company law, partnership. Now the list is not exhaustive. There are of course other aspects too. And equity courts looked at insolvency, some aspects of company law, and trusts. Now this is only the subject area of law, but you also had different remedies. So for instance, common law remedies primarily include damages for breach of contract, compensation in torts, and certain remedies prescribed by statute. Equitable remedies include rectification, rescission, cancellation, and declarations, specific performance, permanent injunction, trust-based remedies, and equitable damages. Now, I've omitted, and I apologize for it, interlocutory injunctions are both common law and equitable remedies. They originated in equity, but later on in England in 1873, the common law courts were also given the jurisdiction to grant interlocutory injunctions. So when it comes to India specifically, equitable remedies are primarily divided into two main statutes or distributed in two main statutes. The first is the Specific Relief Act and the second is the Indian Trusts Act. Yes, there are also additional remedies that are given now by the Insolvency Code, for instance, or the remedy of oppression and mismanagement that is under Companies Act. So those are the additional different other statutes that provide for equitable remedies. Talking about equity in India. Like I said, this is more of a story. So the Indian story of equity, that's actually sort of a pun intended because story is the STORY is also one of the cardinal commentators on equity. But leave that aside. So when it comes to equity in India, primarily from 1773, the British established the Supreme Courts of Judicature at Calcutta, Madras, and Bombay. And these courts were mandated to decide or adjudicate disputes in accordance with equity or principles of equity as prevailing in the Chancery Courts of England. Now, while this was the law, in practice, however, the situation was a lot different. Because you actually had the same judge being designated both as a common law court and an equity court. So what would happen prior to 1861 is you would go to the court with a petition and say, my lords, I have a common law remedy in damages, please adjudicate it. That judge sitting in the first half of the day would be a common law court, and they are actually documented judgments on orders wherein in the first half he says, I'm sorry, I'm rejecting this remedy because you don't have a case in common law. And thereafter, he says, try an equitable remedy. And in the afternoon, you'd go to the same judge with the same petition, albeit asking for a different remedy. The process was so cumbersome because you could have achieved the whole thing in one sitting. You did not go in two separate sittings before the same judge, before the same court, and ask for different remedies. Now, this problem was also in England. However, you had different judges and different courts, but in India, you had the same judge but different courts. So from 1850s onwards, there was a need felt in the common law world to fuse law and equity. India was the test case because in 1861, the Charter Act of 1773 was replaced by the Acts of 1861 and letters patent establishing the High Courts of Bombay, Calcutta and Madras, and subsequently other High Courts by letters patent. And during this time, in 1859, sorry, just 2 years before, for the first time in India, we had the Code of Civil Procedure 1859. The Code of Civil Procedure unified procedure for common law and equity courts, systems of law, that is, albeit it only was applicable initially to Mufussil and Sadr courts, but thereafter also was applicable to the high courts. Now, the Code of Civil Procedure, like I said, unified the procedure for equity and common law. And this experiment was the basis and was highly successful. And in fact, the Indian experiment was the basis in which the English in 1873 passed the Judicature Acts fusing common law and equity. There's a fantastic article written and available on Hein Online in 1876 on how India was the experiment, and I'll send out the link later on to the alumni cell who can circulate it for you. When the 1861 Acts came in, primarily the question was, and I'll not sort of take a pause here to explain this, in common law countries like England, Australia, India, and other countries that were ruled by the British, the primary remedy was always the remedy of damages. The alternate remedy, only if damages were an inadequate remedy, was specific performance. In contrast, in civil law countries, specific performance is the primary remedy and damages are the alternate remedy. And this still holds good today. But in 1859, when the Second Law Commission decided to introduce the Code of Civil Procedure, what they interestingly did is that they introduced Section 192 to the code. And Section 192 said that where the suit is for damages for breach of contract, if it appears that the defendant is able to perform the contract, the court, with the consent of the plaintiff, may decree specific performance within a time fixed by the court, and in such case shall award an amount of damages to be paid in the alternative. So ultimately, pursuant to the Code of 1859, we did away with the common law rule of damages being the primary remedy and specific performance being the alternate. And furthermore, we left the choice to the plaintiff to ask what he wanted. From 1859 onwards, there were huge demands by the plantation owners because they felt that a lot of workers at the plantations were leaving their jobs and running away, and as a result of which the plantations were suffering. They insisted on asking for a criminal punishment for plantation workers who are unable to perform their contracts of employment. By this time, Henry Maine had come in as the Third Law Commission member, along with Whitley Coates, Sir Stephen, who was instrumental in the Indian Contract Act and its drafting. And they then decided to do away with the rule in Section 192 of the Civil Procedure Code of 1859 and revert back to English law by then saying, and this was now introduced in the 1877 Specific Relief Act, by saying that as in English law, specific performance is only the alternate remedy and the primary remedy is a remedy of damages. And further, that specific performance would be granted only if damages are proven to be an inadequate remedy. Now, it's very interesting that something like this happened because there is there was a chance, and in fact, there's a movement, and Shiv Vishwanathan at Jindal University has tried to document how there was a conscientious movement to include civil law concepts in Indian contract law and the other statutes that were codified or brought into force during that time. And specifically, we moved away from it and started reintroducing English law or common law concepts. I'm unable to understand why this was removed, apart from the basis of the plantation workers' owners' demands. If anybody comes across any research, I'd be happy to look into this and revert to you. Having said this, the 1877 Act was the first statute that codified specific relief in India. And when I say specific relief, I say that because specific relief includes primarily specific performance as an equitable remedy, but it also looks at the remedies of rescission, declaration, and cancellation, and also injunctions. I've forgotten to add in this slide, but rectification is another remedy. I'd like to talk here and start with specific performance as the remedy. The general theme of specific performance in the Specific Relief Act is twofold. The first is that it looks at cases in which contracts may not be specifically enforced. I'll give examples later, but these are cases which cannot be adequately compensated in damages. The second theme of specific performance is cases in which contracts cannot be specifically imposed, that is, cases which can be adequately compensated in damages. So to give examples, a contract for immovable property. Property is something, immovable property is something that is very personal to the individual who wishes, or the person who wishes to purchase it. It may have an emotional attachment also. So these are contracts in which a person cannot be adequately compensated in damages because you cannot put a price on what is the value of that property. It may have not only a monetary value, but also an emotional value or attachment. So immovable property comes under the first line of cases. In the 1963 Act, you have specific provisions, section 10 onwards, that deal with immovable property. The second kind is lack of availability of the substitute, which is also considered a basis. So for instance, let's say I enter into a contract with somebody to purchase a painting. Now that painting for person X may be valued at 10 rupees, for somebody may be valued at 1 crore, for somebody it may be priceless. So these are contract, and thereafter if the person reneges on his commitment to sell me the painting, it comes under the first line of cases because I can thereafter not still enforce the contract because I cannot be adequately compensated in damages. The second group, which is contracts which cannot be specifically enforced, I apologize for the typo there, are cases, for instance, employment contracts, contracts which are personal in nature. An exception, for instance, section 14 of the Specific Relief Act talks of personal constant supervision of the court. You cannot, for instance, force an employee to continue working with you. He can leave whenever he wants, subject, of course, to reasonable restrictions as prescribed in the Contract Act. You cannot, for instance, enforce a contract that would require constant supervision by the court. One cannot enforce a contract that is determinable in its nature as prescribed in section 14 and section 41 of the Specific Relief Act. So this is the general theme. The foundation of this remedy, that is the remedy of specific performance, is the inadequacy of damages. It is set out in numerous sections. It starts off with section 10, section 14, section 16. You also have it in section 41. With respect to permanent injunctions in the context of torts, it's also set out as to the harm has to be irreparable in nature. So if one were to ask what is the broad theme of specific relief, it is the inadequacy of damages. It is also the primacy given to a common law remedy of damages over the equitable remedy of specific performance. Sorry. And there are a couple of other remedies, and I just want to introduce them because they sort of set the base as to how to understand specific relief. And I primarily am going to just leave you with a thought here. The next set of remedies are the remedies of rescission, cancellation, and declaration. Uh, to explain rescission, I'm only setting it out for the students because I wasn't taught it in law school. When a contract is void or voidable, a void contract is void ab initio and non-est. It is not required to approach the court for a specific declaration. However, it is still an option for a party. However, when a contract is voidable, that is a contract that is vitiated by coercion, undue influence, fraud, or misrepresentation, the person seeking to exercise his right to declare the contract void must approach the court under section 27 or 31 of the Specific Relief Act that prescribe the remedies of rescission and cancellation and ask for a declaration that the contract is void. I'm specifying this out here because I have noticed with my limited practice that lawyers more often than not do not mention or use the words or remedies of rescission and cancellation, but rather they use a broader remedy of declaration under section 634 of the contract, the Specific Relief Act, by asking for a prayer that this honorable court may declare that the contract is void or declare that the contract is voidable or the like. In practice and in the text of the Specific Relief Act, such a declaration cannot be given under section 34, but must be resorted to under sections 27 and 31. The third kind of a remedy is a remedy of rectification. Basically, it's the power of the court to make changes to a contract as understood between the parties. The fourth kind of a remedy, and something that is now the backbone of civil litigation, are injunctions, both temporary and permanent in nature. Permanent injunctions are governed by the Specific Relief Act from sections 38 onwards, and temporary injunctions are governed under Order 39 of the Code of Civil Procedure, but there are also judgments to say Order 39 of the Code of Civil Procedure is not exhaustive on the law of interlocutory injunctions. I just want to specify here that even when it comes to interlocutory injunctions, the standard conditions for the grant or the criteria for the grant of such injunctions include a prima facie case, irreparable harm, and balance of convenience. So the requirement of adequacy of damages is sort of set out as an irreparable harm requirement even in the context of interlocutory injunctions. When I come to the 2018 amendments, there are important questions that are going to be posed on the status of interlocutory injunctions. So I'll explain that later. But it is important to understand once again that the broad theme of specific relief is the inadequacy of damages requirement. And this is where I want to now come to the 2018 amendments. That's interesting because in the 2018 amendments, when they have been introduced, there is no discussion whatsoever on why the amendments were introduced, but for the statement of objects and reasons. And when I mean no discussion, I mean that ordinarily such drastic changes to a statute are pursuant to a report of the Law Commission or some sort of Supreme Court decision or some drastic need for a change in law. And second, a bill is accompanied by a notes and clauses segment that sets out why each and every provision is changed. In the context of the 2018 amendments, we have only a one-page statement of objects and reasons, and I have just extracted the three main aspects that deal with that are related to the discussion in this webinar. The first is the Parliament said that as a result of wide discretionary powers, the courts in majority of cases award damages as a rule and grant specific performance as an exception. I have just dealt with this earlier to say that yes, this is the process and this is the general structure of specific relief in the statute. Thereafter, the Parliament said that it has been felt, not if, I apologize, it has been felt that the Act is not in tune with the rapid economic growth happening in our country and the expansion of infrastructure activities that are needed for the overall development of the country. And thereafter, it goes on to say that it is proposed to do away with the wider discretion of courts to grant specific performance and to make specific performance of contract a general rule rather than an exception subject to certain limited grounds. I want to just pause here by explaining, and something that I should have mentioned earlier is that the entire running theme of equity is also discretion. That is, when the court is given an opportunity to consider hard rules of law vis-a-vis equity and good conscience, it can, in its discretion, divert from those specific or hard rules and pronounce a judgment that is different or that is not in consonance with such rules. Equity, therefore, also started out as something that is an exception to the principle of stare decisis. That is the principle that a court of law is bound by its own previous judgment. This discretionary aspect of equity has also pervaded in different provisions in India, primary amongst which is Article 142 of the Constitution that gives the power to the Supreme Court to do complete justice, to divert from a settled legal principle. I see some questions. Somebody's asked a question, but I'll come to that later. The point I was trying to make is, with the statement of objects of the Specific Relief Act 2018 amendment, certain sweeping changes were introduced. First, that under section, and I'll just put the slide out here so that everyone can follow. Under section 10 of the Specific Relief Act, specific performance has been made the rule and not the exception. Second, that the requirement of inadequacy of damages has been removed under sections 14 and 16. Third, a new remedy has been introduced, which is the remedy of substituted performance. And fourth is a mandate that a court cannot grant an injunction in respect of certain infrastructure projects which are going to be specified in a schedule. I'll briefly touch upon specific performance and then go to the rest. Sorry, substituted performance and then go to the rest. Substituted performance is a remedy that has been introduced to say that, let's say I have entered into a contract with the party X to perform a contract to build a house over a 2-year period. Party X, after completing 40% of the house, repudiates the contract and leaves. I now have initially had only two options. Either I move the court for damages for breach of contract or ask for specific performance by the same party X. Substituted performance is a remedy that says that if party X has completed only 40% and left, I can thereafter appoint a new party Y and ask him to complete the remaining 60% of the house and claim damages for the difference, that is for the cost of construction of that 60%. It's a remedy that initially came about in civil law countries, but increasingly has been used in civil law, common law countries also. When it comes to the 2018 amendment, I set out earlier that there are, of course, obviously problems because, as I said in my central argument, without any discussion whatsoever, this entire basis has been done away. So the question then arises, where do we find some rationale as to why this has been done? And what is the status now? There has been some discussion in case law on the 2018 amendments, but these discussions are primarily in the context of construction contracts and infrastructure projects and the requirement of the mandate that courts cannot grant injunctions. There are one or two case law that look at specific performance as being the primary remedy, but those observations are merely obiter and don't hold any value, precedential value. So therefore, lawyers and academic researchers are at a loss as to where to find the basis. I propose, and it is my argument, that in order to find the basis, we have to revert back to section 192 of the Code of Civil Procedure of 1859 to then understand why did the legislature in India conscientiously introduce section 192 to give specific performance an equal stature as adequacy as a damages remedy, and left the option to the plaintiff to consent as to which remedy he wants. There is no discussion on this, but I found a lot of guidance from the Tagore Law lecture in 1909 by Mr. Banerjee that has also formed the basis of a book called Banerjee on the Specific Relief Act, albeit in the context of the 1877 Act. And he says that a problem arose because during the Law Commission codification movement, specifically the Third Law Commission, the problems of the drafters was to borrow from the New York codes in the context of the Contract Act and the Specific Relief Act. What they should have done is to borrow from the English experience and understand what are the problems and to go forward and remedy them in India. Now, this, of course, was not undertaken, and hence, for over 120 years now, 160 years now, we have sort of been or sort of dealt or been subjected to the problem of damages being the primary remedy and not specific performance. There are, of course, a couple of other issues that arise, and I'm just going to put forth these as parting thoughts. I notice I'm sort of ending my time, but we need to understand what is the impact of doing away with the 2018 amendment, with the inadequacy of damages under the 2018 amendment on interlocutory injunctions. If we say that interim injunctions are always granted in aid of final relief, which is the standard principle, and adequacy of damages or inadequacy of damages as a final relief has been done away with, does the requirement of irreparable harm in the context of an interlocutory injunction still survive? This is a vexed question. I don't have a specific answer to this. I actually believe there could be a distinction between harm in the context of an interlocutory injunction and harm in the context of specific relief. It could be argued that the harm in the context of an interlocutory injunction is only during the pendency of the suit, and hence it is of a different nature than the irreparable harm or the inadequacy of damages requirement in the context of a final relief. But there is no discussion by the courts on this, and this is something that we'll see going forward. The other issue that arises is doing away with the entire discretionary requirement in specific relief and specific performance. At the heart of every equitable remedy is a discretion. The court may grant an injunction if it feels like. The court may grant specific performance on certain factors and the like. What this 2018 amendment has done is that, specifically in the context of section 10, it has removed the words may and used the word shall, making it a mandate for the court to grant specific performance. Now, this may create problems in the future. I actually think it is important that we acknowledge the equitable or the discretionary aspect of equitable remedies. I want to conclude by what I felt was a seminal article on equity in 1952 written by Lord Denning. This also forms a chapter in his book Learning the Law, and I think all law students should read the 4 volumes of Denning's life: Learning the Law, Discipline of the Law, The Due Process of the Law, and the 4th one, I'm forgetting the name, because it forms great reading to understand how common law works, specifically civil law. Now, Denning in his article in 1942 actually looks at this question of discretion. And he says that uh, when Henry Maine started the codification process in India and, of course, started asking for law to be codified even in England, there were three foundations, which is legal, equitable, and you had the common law foundation, you had the equitable foundation, and you had the legislature stepping in. And the function of all of these was to fill the gaps or plug the holes where the law was inadequate. Equity was a little different because in England, equity took primacy over the common law. So there was the discretion of the court to sort of grant an equitable remedy when allowed or when the court felt so. However, in 1952, Denning noticed that more and more this discretionary aspect of equity has come to a standstill, and there is no difference between the Chancery Court and a common law court when it is exercising its discretion, because they both don't have any discretion. And Denning felt that there is therefore a need for a new equity that lays the stress on discretion given to a judge to decide a case in accordance with what he feels right and the circumstances at that current time. Perhaps we may want to consider, and this is the closing note, that if the 2018 amendments have sort of done away with the foundation of specific relief and the discretion given to a court to grant specific performance, is it still possible, or is there still any room in a civil law context, that is a commercial context, for courts to exercise their discretion in granting a particular remedy? And with that, I'd like to close this. I hope this was an enjoyable discussion, and I shall now take questions. So I have a question first by Yash Dodani, asking me what is the difference between section 27 and section 34 of the Specific Relief Act? Are both sections the same? Yash, this is something that I sort of brought up in my webinar. Section 27 is the remedy of rescission. That is the remedy where a party can approach court in the context of a voidable contract and ask for it to be declared void. The circumstances in which a court or a party can ask for this sort of a remedy are set out in section 27 itself. Section 34, in my opinion, is not a universal remedy. It's not an all-encompassing remedy, but it's a residual remedy. That means it is still a power of the court to grant a declaration. However, it is only in those circumstances wherein sections 27 and 31 are inapplicable. I must also set out here that there is a power of the court to grant declaratory remedy even beyond section 34, and that power arises from section 9 of the Code of Civil Procedure. I have another question by Vardhan asking me to elaborate on the requirement of adequate performance being done away with. Does it mean that virtually every commercial contract can be specifically enforced? So good question, Vardhan. And in my opinion, after the 2018 amendment, the answer is yes. If the plaintiff wants, virtually every commercial contract can be specifically enforced. I think this is interesting and this is good, but I must also tell you, from the time these amendments were notified till so far, till date, in my current experience, I haven't seen plaintiffs asking for this. But yes, it is a possibility, and I think it's very soon we'll start seeing such reliefs. I have a question by Rishabh Raheja saying, would you say that an arbitral tribunal has the same powers of the court to order specific relief? If your answer is yes, would you reconcile with this fact, with the fact that the courts cannot review the merits of the arbitral tribunal's award? So Rishabh, to first answer your question, there is a Supreme Court decision called Olympus Superstructures in the late 1990s that said that the arbitral tribunal has the power to grant reliefs under the remedies under the Specific Relief Act. So that position is well established in India. And Yes, how would you reconcile this? I don't see any need to reconcile this with the merits principle under section 34, that a tribunal would not review merits, because this is something that has been in practice since Olympus superstructures, that even if the court, a tribunal grants an award of specific relief, it will still not be able to review the merits of the case. You ask another question saying, giving your reasons. You say that since the court will ultimately have, what if you present a court with an award of specific relief that would not be granted by a court? The court cannot review the merits of such an award, but the court may have to supervise the enforcement. Very interesting question. The second part. So while the inadequacy of damages as a ground of specific performance has been removed, constant supervision is still a requirement specified in section 14. So if an award of the tribunal is contrary to section 14(1)(b), that is the requirement of constant supervision, it could be argued that the award is contrary to public policy of India, which pursuant to decisions of the Supreme Court also includes contrary to law, and therefore the award will be set aside. I have a question by Shreya saying that she's she's not able to comprehend my concerns about the parameter of irreparable damage in granting an injunction being done away with under the 2018 amendments. So Shreya, I just put it out there, but just to let, my point was that in the context of interim injunctions, there is a requirement that the parties suffer irreparable harm. Now, irreparable harm means that the harm cannot be compensated by damages, which in effect means that harm in respect of which damages are an inadequate remedy. So ultimately, it could be argued that the requirement of irreparable harm and inadequacy of damages are similar in nature. If that is the case, and the 2018 amendments have done away with inadequacy of damages as a requirement for final relief, its impact on interlocutory injunctions asking for irreparable harm is yet to be considered, and it is a question. This was my point. Okay. I don't see, sorry, I have one more question by Nickelodeon. Is substituted performance already not present under contract law, given that a party can claim additional damages for the cost it incurs from getting the contract performed by another party? So Badrinath Srinivasan wrote an interesting article in the SEC on the remedy of substituted performance and how it could work in India. I would request you to look at that article. There are one or two cases that look at this asking from a third party. That, in my opinion, arises from the principle of mitigation of damages. However, there is no codification of this remedy in Indian law. The contract law does not have a provision even for mitigation of damages, and therefore the Specific Relief Act has introduced that remedy. Vardhan asked me another question saying, how do I read shall be enforced and the exception of determinable contract? Almost every contract is determinable as well. I actually beg to differ. There is a distinction specified under section 14 and section 42. The word determinable is specified under sections 14 and 42 of the Specific Relief Act. Contracts are of two kinds. A contract that is executed and is complete then and there. For instance, a contract for sale of property, the moment the property is sold, or a contract for the purchase of a good, the moment you pay the money, it is complete. That contract is not a determinable contract. However, there are certain contracts that are to be performed over a given period of time. These contracts are also considered contracts that are executory in nature. And in that context, these contracts are construed as determinable contracts. So your basic premise that almost every contract is determinable is actually incorrect. There is a clear distinction in contract law as to contracts which can be terminated and contracts which can't. Okay, I don't have any other questions. So on that note, I'd like to end this talk by thanking the NALSAR alumni cell I also want to thank Rupen Bell for organizing this. And once again, if anybody is interested in giving a talk to the NALSAR Alumni Cell, I'd request you to contact the cell or contact Tilak. They also have a LinkedIn page. And I'm sure they're going to schedule a talk, and the students would be happy to hear your experiences and your views. Thank you very much, everyone. It was a pleasure.